describe what will happen during the course of the trial. I'll explain my role as the judge, the lawyer's role as advocates in this case, and your role as jurors. I will discuss some of the legal rules that apply in this case. And finally, I will explain some important things that you all must do during the course of your service as jurors in this case. And just as importantly, things you must not do. So turning first to the indictment that Ms. Draper just read, you must keep firmly in mind that an indictment is merely a legal document that formally accuses someone of a crime and nothing more. So the indictment itself in this case is not evidence. And the fact that the defendant, Judy Church, is facing this charge does not mean that she is guilty of committing the charged offense. As I told you when we were choosing you as our jurors, Ms. Church has pleaded not guilty to the charge, and she denies the Commonwealth's allegations. At the end of the trial, you will decide whether the prosecution has proved that charge beyond a reasonable doubt. Now I'm going to explain how the trial will proceed. When I finish with these initial instructions, the prosecutor and defense counsel will make opening statements to you. An opening statement is a summary of what the lawyer expects the evidence will show. After the opening statements, you will hear testimony from various witnesses, and the evidence may also include documents and other things such as photographs, surveillance video footage, and tangible items. The prosecution will call witnesses first, and then Ms. Church, as the defendant, will have the chance to call additional witnesses if she chooses to do so. But she's under no obligation to call any witnesses or to produce any evidence because the burden is exclusively upon the Commonwealth to prove that she is guilty. A defendant in a criminal trial is entitled to sit back and say to the Commonwealth, prove it. But if a defendant chooses to present any evidence, the defendant does so after the Commonwealth has rested, that is, after the Commonwealth has completed its presentation. After both sides have rested, and you've seen and heard all of the evidence that's been presented, the attorney for each side will present a closing argument to you. A closing argument is an opportunity for each of the attorneys to sum up for you the evidence that you've heard, suggest what inferences and conclusions you should draw from it, and ultimately what verdict you should come to. The lawyer's opening statements and their closing arguments are important parts of trial, and they may help you make sense of the evidence, but you must bear in mind that they are not evidence themselves. At the end of the trial, I will instruct you in detail on the legal rules that you must apply in deciding this case. And then after we randomly select 4 of you to serve as our alternates, the remaining 12 jurors will then engage in what we refer to as deliberations. That is, you will privately discuss the evidence that you've heard, and you will come to your verdict in this case. So now I'm going to talk a little bit about the respective roles of the participants in this case. My job as the judge in this case is to make sure that this case is tried fairly, efficiently, and according to the law. I must make sure that what you see and hear during the course of this trial is allowed under our rules of evidence. Those rules determine what evidence the lawyers may and may not present to you. The purpose of these rules is to make sure that what you do see and hear during the course of this trial is relevant to the case and appropriate for you to consider. If one of the lawyers says objection to a question that another lawyer asks of a witness, that means the objecting lawyer thinks that the testimony that's sought to be elicited from the witness would violate our rules of evidence. Likewise, a lawyer may object when the other side offers an exhibit into evidence for the same reason. If I'm not persuaded by the objection, you will hear me say overruled, and that means the witness will be permitted to answer the question that's been put to the witness, or the proposed exhibit will be admitted and you may consider it. If instead I say sustained in response to an objection, that means I think the objection is well taken and I will not permit the witness to answer the question or the proposed exhibit to be admitted. If I do sustain an objection, it's fundamentally important that you not talk about or try to speculate or guess about what the answer may have been to a question that I did not permit the witness to answer, or what the content of an exhibit may have been that I did not permit to be admitted. There may be times during the course of the trial when I tell you to disregard something that you've already heard, or I order something you've already heard stricken from the record. If that occurs, you must completely disregard whatever you've heard because it is not part of the evidence and may not be considered by you. As I've told you, I as the judge will explain the law to you. At the end of the trial, I will give you detailed instructions about the law that you must follow, far more comprehensive than the instructions I'm giving you right now as a preliminary basis. At that time, I will provide written copies of these instructions to each and every one of you so you can read along if you wish while I deliver them orally, and you will have those written copies of instructions for use during your deliberations if you wish to refer to those instructions. Now, the lawyers have their own very important role in this trial. Their job is to bring to your attention the evidence and arguments that best support their respective positions. They may, as I've also indicated, object to evidence that's offered by the other side. Please do not hold it against any of the lawyers or the parties that they represent if they do make an objection, regardless on how I rule on that objection. They're just doing their job as advocates in this case, and they must bring to my attention anytime they think something may violate our rules of evidence. During the trial, you may hear an attorney occasionally ask to see me at what's known as sidebar. That's where we go over to the end of my bench and the attorneys and I have a little private conversation. It may be that the attorneys want me to reconsider a ruling I may have made in response to an objection in an open court, and we do not conduct any protracted discussions on legal issues in the jury's presence. Maybe they want to preview for me something they want to do and want to get permission in advance. And it may be that I want to see the attorneys at sidebar because sometimes if there's an objection, for example, I need to know from the attorney what the expected answer to the objection is before I can determine whether that answer would be admissible or not under our rules of evidence. We will try to keep these sidebars to a minimum, but bear in mind, nobody's trying to keep from you evidence that you should hear. Exactly the opposite is the case. We're trying to make sure you don't hear anything you're not supposed to hear under our rules of evidence. So it would defeat the purpose of a sidebar conference if you try to listen in to what we're saying. We usually put on a white noise machine. It's really kind of dreadful, but we put that on during these sidebar conferences. And I give you permission in advance. Anytime we go over the sidebar for one of these discussions, if you wish to stand up quietly and stretch in place, move around a little bit, you may do so. Now, that brings us to your role in this case as jurors. You have the most important role in this trial. After you've seen and heard all of the evidence, you alone will decide who and what to believe and whether the prosecution has proved that Ms. Church is guilty of the charged offense based on the legal principles that I will explain to you. You must decide this case based only on the evidence you see and hear during the trial and on my instructions of law. In considering the evidence, you may and should bring to bear upon such consideration your common sense, your life experience, and your intelligence. What you may not do is decide this case based on suspicion, guesswork, or speculation. The evidence will consist of the testimony of the witnesses, as you recall it, and any documents that become exhibits or tangible items. Other things that you will see and hear during the course of this trial are not evidence. For example, as I've already told you, the opening statements and closing arguments of the attorneys are helpful to you, but they are not evidence. And the questions that the attorneys ask of witnesses are not evidence. You must bear in mind that it is the witnesses' answers to the questions that constitute the evidence. So you should only consider the questions to the extent that they give context and meaning to the witnesses' answers. To make this principle a little bit more concrete, if you imagine that we were trying a civil motor vehicle case, and a lawyer asked the witness, "Didn't you see the car drive right through the red light into the intersection and crash into the other car?" And the witness says, "No," or "I don't remember." There is no evidence before that jury that a car drove through a red light and crashed into another car because the witness didn't affirm any of the information that was in the question. As I just told you, the question itself is not evidence. So do bear that in mind. A very important part of your job as jurors is to decide who and what to believe. Whether testimony is contradicted or not, it's entirely up to you whether you believe it. You have great discretion in this regard. You may believe everything a witness tells you, some of it, or none of it. Again, that's entirely your prerogative. In deciding who or what to believe, you should ask and consider some important questions. First, was the witness honestly trying to tell the truth or deliberately lying? Although witnesses take an oath to tell the truth, sometimes a witness says things that the witness knows are false. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. You may also decide, or not, that such a lie causes you to disbelieve other testimony by that witness. Second, ask yourself, was the witness accurate, or did the witness get something wrong without meaning to do so? Sometimes a witness may recall seeing or hearing something, but still be mistaken. If you conclude that a witness tried to be truthful, but that some part of the person's testimony was not accurate, then you should not consider the inaccurate testimony. Again, you may decide, or not, that such mistaken or inaccurate testimony causes you to disbelieve other testimony by that witness. Please bear in mind during the course of this trial that I have no opinion about who or what you should believe or about how you should decide this case. So please don't take anything that I may say or do during the course of this trial, any rulings I make, any body language I may display, as suggesting to you who or what to believe or how you should decide this case. I have no opinion about the facts of this case. It is your responsibility and yours alone to decide this case, and you must do so free from interference from anyone, myself included. Now I want to talk about some fairness principles. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have all agreed to be fair, and I am sure that you want to be fair, but that's not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we aren't aware of them, and even if we believe we don't have them. Some of you may have heard this referred to as unconscious or implicit bias, and that's what I'm referring to. We judges have the same problem as everyone else, so I'm going to give you some strategies that we have found useful to deal with this issue. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind throughout the trial. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you do ultimately deliberate, you will have all the evidence before you, and you will have all the time you need to make a careful decision. So there's truly no need to start making up your mind before then. Third, you should listen closely to all the witnesses. That is the very best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may make. All we ask is that you individually and as a group do your very best to resolve this case upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now I'm going to turn to legal principles. There are certain legal rules that you must follow in this case. I'll discuss them, as I've said, in detail at the end of the trial, but here are some key things you should know from the beginning. And as you listen to the initial part of these instructions, I think you will recall that I discussed many of these things with you during the impanelment process. First, everybody who is accused of a crime is presumed innocent of that crime. Ms. Church is presumed innocent of the charge in this case. That means you must consider Ms. Church to be innocent now, and you must still consider her to be innocent at the end of the trial, unless the prosecution has proved beyond a reasonable doubt, through evidence presented during the trial, that Ms. Church committed the charged offense. I'll explain what I mean by reasonable doubt in just a moment. Ms. Church does not have to do anything to convince you that she is innocent. She does not have to explain anything. Ms. Church does not have to testify, call, or even question any witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charge against Ms. Church beyond a reasonable doubt. And this burden of proof that is placed upon the Commonwealth never shifts to a criminal defendant in a trial. At the end of the trial, after you've seen and heard all of the evidence, you will deliberate with each other, as I've said, meaning you will discuss the evidence and decide on your verdict. If you have a reasonable doubt about Ms. Church's guilt, then your verdict must be not guilty. You may find Ms. Church guilty only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. And you may only find the defendant, Ms. Church, not guilty if all 12 jurors agree that the Commonwealth has failed to prove the charge beyond a reasonable doubt. In other words, regardless of what your verdict may ultimately be, it must be unanimous. All 12 jurors must agree. So, as I've said, the burden is on the Commonwealth to prove this charge that has been brought against Ms. Church beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty that's possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, Miss Church is entitled to the benefit of that doubt, and she must be acquitted. That is found not guilty. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason in judgment as jurors who are sworn to act conscientiously on the evidence. That's what we mean by proof beyond a reasonable doubt. The Commonwealth in this case has brought a single charge or indictment against the defendant, Miss Church, charging her with the crime of murder in the first degree. Under our law, there are two different degrees of murder, murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the Commonwealth committed murder in the first degree on two separate theories, that the murder was committed with deliberate premeditation and that it was committed with extreme atrocity or cruelty. To find the defendant guilty on either of these theories of murder, you must be unanimous, as I've explained. What that means with these two theories is that all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of a particular theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I will begin by instructing you on the elements of each of these two theories of murder in the first degree, and I will then instruct you on murder in the second degree. I came down with a pretty bad cough between yesterday and today. It's making this a little challenging. I apologize. So I will first define the elements of murder in the first degree with deliberate premeditation. To prove the defendant, Miss Church, guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove each of the following beyond a reasonable doubt. First, that the defendant, Judy Church, caused the death of the victim, Leroy Fowler. Second, that Miss Church intended to kill Mr. Fowler. That is, Miss Church consciously and purposely intended to cause Mr. Fowler's death. And third, that Miss Church committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I will now discuss each of these requirements a little bit more. The first element is that Miss Church caused the death of Mr. Fowler. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that Miss Church intended to kill Mr. Fowler. That is, Miss Church consciously and purposely intended to cause Mr. Fowler's death. The third element is that Miss Church committed the killing with deliberate premeditation, as I said, that is, after a period of reflection. Deliberate premeditation does not require any particular time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. I will now define the elements of murder in the first degree with extreme atrocity or cruelty. You shall consider the theory of murder in the first degree regardless of whether or not, you shall consider this particular theory of murder in the first degree regardless of whether or not you find the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove Miss Church guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove each of the following elements beyond a reasonable doubt. First, once again, that Miss Church caused the death of Mr. Fowler. Second, that Miss Church either A, intended to kill Mr. Fowler, or B, intended to cause grievous harm, bodily harm, to Mr. Fowler, or C, intended to do an act which in the circumstances known to Miss Church, a reasonable person would have known, created a plain and strong likelihood that death would result. The third element is that the killing was committed with extreme atrocity or cruelty. I will now explain these elements a little bit more. The first element, that Miss Church caused the death of Mr. Fowler, is the same as the first element of murder in the first degree by deliberate premeditation, and the very same instruction applies. The second element is that the defendant, once again, A, intended to kill Mr. Fowler, or B, intended to cause grievous bodily harm to Mr. Fowler, or C, intended to do an act which in the circumstances known to Miss Church, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has three sub-elements, which I'll refer to as prongs. The Commonwealth satisfies its burden of proof if it proves any one of the three prongs of that second element beyond a reasonable doubt. The first prong, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Mr. Fowler, the decedent. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a strong and plain likelihood that death would result. Let me help you understand how to analyze that third prong. You must first determine whether Miss Church intended to perform the act that caused Mr. Fowler's death. If you find that she intended to perform the act, you must then determine what Miss Church herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under those circumstances known to Miss Church, a reasonable person would have known that the act intended by Miss Church created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether Mr. Fowler's death was accidental, because the death was caused by a negligent, careless, or mistaken act of Miss Church, or resulted from a cause separate from Miss Church's conduct, you may not find that the Commonwealth has proved that Miss Church intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in the taking of any human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and the resulting effect on the victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that Miss Church caused the death of Mr. Fowler with extreme atrocity or cruelty, you must consider the following three factors. 1, whether Miss Church was indifferent to or took pleasure in the suffering of Mr. Fowler. 2, whether Miss Church's method or means of killing Mr. Fowler was reasonably likely to substantially increase or prolong the conscious suffering of Mr. Fowler. And 3, whether the means used by Miss Church were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by Miss Church were excessive and out of proportion to what would be needed to kill a person, you may consider the extent of the injuries to Mr. Fowler, the number of blows delivered, the manner, degree, and severity of the force used, and the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the three factors that I have just listed. Now I turn to the requirements of proof for murder in the second degree. They are the very same as murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. Consequently, in order to prove murder in the second degree, the Commonwealth must prove the following two elements. First, that Miss Church caused the death of Mr. Fowler, and second, that Miss Church either A, intended to kill Mr. Fowler, or B, intended to cause grievous bodily harm to Mr. Fowler, or C, intended to do an act which in the circumstances known to Miss Church, a reasonable person would have known created a plain and strong likelihood that death would result. And I've already explained those elements to you. So, moving on to a few other administrative matters before I wrap up. At the end of the trial, as I've told you, you will meet in private to deliberate, and you'll have all the exhibits with you at that time. We cannot provide you with any transcripts of any witness testimony, so you need to understand that from the outset. So you'll have to rely on your memory of what each of the witnesses told you. You may take notes during the trial if you wish to do so. After the opening statements, we will distribute notebooks and pens to everyone. Some jurors find it helpful to take notes while listening to the evidence. It may help them focus on the testimony and remember what the witnesses said. Some of you may not want to take notes, which is fine. Whether you take notes or not is entirely up to each and every one of you. Whether you take notes or not, you need to pay close attention to what each witness says and how they say it. In deciding who and what to believe, you should watch and listen to each witness carefully. Think about whether the witness seems believable, whether the witness's memory seems reliable, and anything else about how the witness testifies and what the witness says that helps you decide whether and how much to believe the witness. When you deliberate at the end of the trial, remember that it is your memory of the testimony and evidence that counts. Your notes may help jog your memory about what a witness said, but they are not a substitute for what you or other jurors remember about the testimony. Do not assume that because you or another juror wrote something down, that is more accurate than your or another juror's memory of what the witness actually said. Your notes are confidential. No one, including me, will read them. The court officers will collect your notebooks and pens at the end of each trial day and keep them safe until they're returned to you the next day. And when the trial is over, they will tear out the contents of each notebook and shred them without looking at them. If you have any trouble hearing or seeing during the course of the trial, just raise your hand or let one of our court officers know, and we'll make any necessary adjustments. We generally take a morning recess at about 11. We do not usually take a break in the afternoon after our 1 hour lunch break. We typically sit for 2 to 4 without a break. But if you need a break at any other time during the course of the trial, don't hesitate to raise your hand or let us know. We're always willing to take a quick break. If you need to stand and stretch and move around a little bit, don't hesitate to do that. We will accommodate that. If you find your attention flagging, your eyes are going to half staff a little bit, and you're really struggling to stay awake, don't be embarrassed by that. That's a very, very common phenomenon. I've never been a judge in juror in an actual trial. I've always wanted to be, but it's never happened to me, even though I get called for jury every 3 years, just like most people. But I was a juror in what they call a mock trial at one of our prestigious local law schools, and I was seated in the front row of the jury room, and I discovered pretty quickly that I couldn't stay awake. It's very hard to passively listen to information. So if you are struggling, we try to pay attention. You may all of a sudden hear me say, let's stand up and take a stretch break because I notice someone may be struggling. But don't hesitate to ask for a break for that reason. We'd much rather take a 5-minute break, allow you to recaffeinate or step outside and get some fresh air and come back revived, because we don't want anybody to miss anything during the course of the trial. So again, don't be embarrassed by that. We can deal with that. Now, I want to give you some cautions, those things that you must do and must not do as jurors. So, do keep an open mind throughout the trial. You must not decide the case until you've seen and heard all the evidence, and listen to my final instructions at the end of the trial. Do not discuss the evidence or this case with other jurors until you start your formal deliberations at the end of the trial. And this is because it can be hard to keep an open mind if 2 or more of you start discussing the evidence before the end of the case. Do not talk to or communicate with anyone else about this case until after you reach and deliver your verdict and I tell you that you've completed your jury service. And this is because you have to decide this case based solely on the evidence presented in this courtroom, and you must not consider any other information or opinions. And when I say that you may not communicate with anyone else about the case before you've reached your verdict, that means you may not do so in any way, including through the use of a cell phone or other electronic device. So until you reach your verdict and return it in court, you may not text, chat, email, tweet, blog, or post anything else about this case using social media or other electronic media or in any other way. You have to wait until the trial is over and you've reached your verdict before you say anything about this case to others. In this day and age, when many people feel the need to tweet, post, and blog about every aspect of their life, no matter how mundane, if you are one of them, you may continue to do so about every aspect of your life except this one. You may not do so about your jury service in this case or anything having to do with this case until that jury service is completed. You may not talk to the parties, the lawyers, or the witnesses during this trial. So if, for example, in the comings and goings, you see one of the lawyers and they just turn away or just give you a curt nod, they are not being rude. They are simply avoiding any interactions with you outside the confines of this courtroom during the court day, and you must do the same. You must avoid any interactions with any of the participants in this case outside of what occurs in this courtroom in my presence. Do not do any research or investigation about this case online or in any other way, or have anyone else do it for you. So do not visit any place mentioned during the trial. Do not Google or search for the names of anyone participating in this case or anything else about it. Once again, this is because you have to decide this case based only on the evidence that's presented in my instructions on the law. Compliance with these instructions is a part of your oath as jurors, and a violation of these instructions could impact the fair administration of justice. So every morning when we first convene, I will pose 2 questions to the jurors as a whole to ensure that you're following the most fundamental of these rules. And within a few days, you'll be able to recite these questions yourself. I'll first ask, since we last saw each other, has any member of the jury discussed the substance of this case with anyone, including among yourselves? I will then ask whether, since we last saw each other, any member of the jury has seen, read, heard, or overheard anything from any outside source about any aspect of this case. You'll want to be able to provide emphatic no responses to those questions every morning when I pose them, and I require all jurors to answer right out loud when I do. If any issue should arise during the course of this trial about your exposure to any outside information, or any other issue should arise that you think might in any way impact your ability to continue to sit as a fair and impartial juror, please do not discuss that issue or that information with any of your fellow jurors. Rather, let one of our court officers know, and if need be, counsel and I can meet with you privately. We'll hear what the issue is and we'll resolve it with you alone without involving any other jurors. Now, jurors, I know that you will try this case according to the oath that each of you have taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, if you approach this case with a truly open mind and make your decisions fairly and without prejudice or bias or sympathy for anyone, I'm confident that at the conclusion of this case, you will arrive at a fair and just verdict. Do any counsel need to see me at sidebar about any of my instructions? All right. Once again, flawless instructions. Jurors, I'm going to have you stand up right now. He's going to sleep with you before you get up. So move around a little bit.